Good afternoon, and thank you for joining us today. This is Anita Beecher of Fortney Scott, and I'd like to welcome you to the Fortney Scott webinar entitled EEOC and Trump 2.0. This webinar is currently being recorded. Today's presenters are Fortney Scott attorneys David Fortney and myself, and our special guest, Victoria Lipnick, former EEOC commissioner and acting EEOC chair, who's now a partner at Resolution Economics and leader of the firm's Human Capital Strategy Group. I'm going to now turn this program over to David Fortney.
Thanks, Nita, and welcome everyone. It's great to be with you. Let me just quickly go through some of the initial slides, and then we'll just jump right into the program. And Vicki, special welcome. We're delighted to have you. This is like a double header,
yeah.
So we spend so much time, really, the three of us, kibitzing and trying to stay abreast of these developments. And so this is a pretty organic, natural discussion and kind of a continuation of what we spend a lot of time doing. I think
nice to be here live in person.
Live and in person, yes. And Nita, I'm sorry you're out of town today, not with us in the same room, but you're with us otherwise completely.
In spirit, David, in spirit.
In spirit, yes, for sure. I think most of you are familiar with the work that both of our firms do, but just generally, Fortney Scott, we do represent employers on a full range of issues relating to the workplace matters, and particularly with respect to the workplace agencies. With respect to Vicki's firm, Resolution Economics, they're certainly one of our go-to service providers. And Vicki, do you want to give just a brief description of the firm?
Sure. So Res Econ, as we like to call it for short, is a specialized consulting firm. We do a lot of work in the litigation space, provide consulting and expert witness services, a lot of data analytics. I spend most of my time with PhD labor economists, of which I am not one.
So we're actually part of your diversity program today.
Exactly.
We're getting some diverse thought and experience.
Yes. And big labor and employment practice, class action cases, also a financial advisory services practice. And I often get retained for consulting purposes, expert witness purposes, monitorships, all of that.
Right. Well, we're so happy to have you with us today. Well, we're going to spend just about an hour, so I want to be really smart about our time and take advantage of the expertise that we've got on this call. I want to quickly give a rundown on the status of the commission, what the EEOC has been up to, and then acting chair Andrea Lucas. She's been very transparent about what her priorities are, but we'd like to spend a little bit of time kind of unpacking each of those priorities, discussing them, what has happened, what a little bit of crystal balling, what we think will happen. Of course, we have the significant and I would say somewhat controversial executive order that President Trump signed, addressing limiting the application of the disparate impact theory of liability under Title VII and Title VI and others. And then also unpack a little bit of the guidance regulations, the EEO1, which the data collection has just opened up, but some little nuances on that. And then we'll try to give you our best guess on what's next. I don't know, if we all sit here nervously with a Pavlovian response, looking at our phones, and we also will try to pick up the Supreme Court decision that was issued just an hour or two ago on that. So I think let's just jump right into it.
So I think as we get ready to do this, we're going to turn to Vicki to tell us what is going on at the EEOC as far as the commission, who's on the commission and so forth, and where all of those nominations stand.
Sure. So the commission is by statute a 5-member commission. It is currently a 2-member commission. And acting chair Lucas, who's been on the commission since 2020, she actually took my seat on the commission, is both commissioner, acting chair. She has been renominated for a second term to the commission. The way the nomination process works, if you are a sitting commissioner, the terms normally expire July 1st, and they are staggered terms. assuming that the Senate gets around to confirming her sometime this summer. But even if it doesn't by July 1st, she can hold over. There's a provision in the statute she can hold over until the end of this session of the Senate. So it could go all the way till the end of this year. I would expect that they will get her confirmed before then. And then the other current sitting commissioner is Kalpana Kodagal. She's one of the Democratic commissioners. She's been there for, I think, over 2 years now. It would have been 3 years, I think, but had a protracted confirmation process, as many of them are these days. So they are the two sitting commissioners. That means the commission does not have a quorum. And so there are certain things that the commission, policy-wise, cannot do without a quorum. And we'll talk about that a little bit more. And then also there is a new nominee for one of the Republican seats that's open, Brittany Pannuccio, and apologies if I am not pronouncing that correctly. I think that's probably how it's pronounced, but I'll definitely learn that. And she's nominated to fill one of the empty seats on the commission. So she is the only nominee right now. There is no nominee for the general counsel's position, which is also requires a presidential nomination and Senate confirmation. There's an acting general counsel right now, but he's nominated to be the head of the wage and hour division at the Labor Department. So we're still waiting to see who might be the general counsel nominee. But once confirmed, assuming the new nominee is confirmed and acting chair Lucas, then that would establish a quorum and also a Republican voting majority on the commission. And so acting chair Lucas would then be able to move some of the policy things that she's made it very clear she's interested in moving, but just doesn't have the votes to do right now.
Just one or two quick thoughts on that. The acting general counsel, Andy Rogers, we've picked up some information that his confirmation hearing to head the wage hour division, so he'll be moving back to the Labor Department. He started at the Labor Department, has been counsel for Commissioner Acting Chair Lucas. She then put him in the acting general counsel role, assuming he's confirmed. Every expectation is he will be. Then the interesting question is, well, who becomes the general counsel? Historically, there's been some instances, I mean, that you can have another acting general counsel, just as Lucas named Rogers, who had been her counsel to serve as the acting general counsel. There's been one or two instances in the past, Vicki, if I'm recalling, where actually the chair decided that the chair would also serve as the general counsel, acting general counsel.
Yeah.
Is that right?
Yes, that's the case in the George W. Bush administration when Carrie Dominguez was the chair of the EEOC. So she named herself. The general counsel position was open until our friend Eric Dryban became the general counsel. So she served as in both positions, and I think Charlotte Burrows, at the beginning of the Biden administration before Carla Gilbride was confirmed as chief.
So that could happen. I just highlight that. Yeah. That wouldn't be unprecedented. I don't want anyone clutching their pearls saying, "Oh my gosh, what's going on over there?" It's happened, whether it's a Republican or Democratic-led commission, that has occurred. So maybe it'll occur. We don't know.
I will say, by operation of law, if there is a career senior executive deputy general counsel, which there is currently at the EEOC, then if there is a vacancy, unless there is someone named by President Trump, as Andy Rogers was, then that person becomes the general counsel.
By operation of law. Okay. So maybe that's what will occur. Very good.
Couple of things, I'm sorry, just a couple of things I wanted to mention. As I understand it, no hearings yet have been scheduled for either the renomination of Lucas or the new person whose name is hard to pronounce for me, Pannuccio. But there was a letter sent by a group of civil rights groups requesting that there be a hearing because they have some deep concerns about both Lucas and Pannuccio. Lucas because they don't agree with her positions, and Pannuccio because she doesn't have an employment law background. So just an FYI.
Although my crystal ball tells me when you look at the votes in the Senate, that sound and fury is unlikely to impact the ultimate vote. But stranger things have happened during the confirmation process, so we'll see.
And I think not an unexpected
Right.
letter sent to the Senate by the civil rights group.
Right. All right.
So I think quickly, we just want to look about what is going on with the two Democratic commissioners, former Chair Burrows, who Vicki, you just mentioned, as well as Samuels, who were fired by President Trump. Samuels has filed a lawsuit in April, but based on this, basically alleging that EEOC was an independent agency and that Trump couldn't fire her without cause, I think the Supreme Court's decision in the recent case of Gwen Wilcox, the NLRB member, probably negates the possibility of Samuels getting her position back under those situations. And Vicki, you have a belief that in fact the EEOC has always been an executive agency and not independent.
Yes, I mean, that is longstanding Department of Justice interpretation of the EEOC's statute. And by the way, the statute for the National Labor Relations Act actually has a provision, language that says members can only be fired for cause, malfeasance. There is no such language like that in the EEOC statute. So as much as I admire former Vice Chair Samuels, I think she was going to have a tough legal road to hoe to begin with. But even with the statutory language, longtime opinions by the Department of Justice in many administrations saying, no, the EEOC is not an independent commission, that commissioners serve at the pleasure of the president. So if it does actually go further in litigation, I think it will be an interesting decision in terms of interpreting that. But I think it's a tough legal argument. And there was, in fact, a commissioner under Jimmy Carter who left, and there's a federal district court case in the District of Columbia that also says, nope, not an independent commission. So I will say that in my time at the commission, one of my colleagues believed that there was a good argument because the commission has partially a judicial function. It decides cases for federal employees, and that can be one of the indicators of a commission that is independent. But I think the whole notion of independent commissions overall is certainly being tested in a big way right now.
Sure, being tested, and I think there's a lot of practices and perceptions that have been allowed to develop that are not necessarily fully grounded on the statutory framework. I mean, that's how things have evolved. But when you call the question, which is effectively what's being done now, and sort of pull out and start flipping through the statute, the black letter law is exactly as you've described it. So what that translates is, for Jocelyn, I'm sorry, you're going to lose. But
David, you ready to kick it off?
Sure. Well, let's talk about, because obviously Andrea Lucas has been the acting chair now for, 140 days-ish. I've sort of lost track on where we are, but from the outset of President Trump's term, she has pushed a very aggressive, and every administration, I mean, this again, because I think there's a lot of spin up, and I want to take a little bit of that off. Every administration comes in and says, we have different priorities, we have different areas we're going to emphasize, different policies. Now, maybe the changes here are more radical, more of a departure than is typically the case. The pendulum swinging, and someone described it, yeah, but it feels like the pendulum's crashing through the side of the clock. I don't know, maybe that is the case or not, but in any event,
and every chair does.
And every chair does, right? Who has significant.
Every chair picks and chooses issues that he or she is really interested in,
and has the discretion to really drive the agenda for the agency. And Vicki, on this point, it doesn't matter whether you're confirmed or acting chair.
That's right.
Your authority is the same.
Completely, you are doing the job 100%.
Okay. So obviously, DEI, LGBTQ plus, anti-Semitism, sorry, tongue-tied there, and anti-Americanism has become some of the key areas that have received much more attention. And Vicki, why don't you kick off? We have all spent a lot of time on the DEI changes, but let's jump off on that point first.
Sure. And let me say also in terms of both changes for DEI, but as you said, every administration, obviously, I mean, we're all aware that President Trump has issued an unprecedented amount of executive orders. Right. Last I checked a week ago, it was like 157. I'm sure it's more since then.
Well, he issued a couple this week, so okay, we're closing in, or we may have met the 160 mark. Yeah.
So, but I will say, the other unprecedented piece, if you're sitting over at the EEOC, as Andrea Lucas is, as the acting chair, is how many times the EEOC has been given direction, called out by name, yes, in various executive orders, including the initial one, 14173, which is the one that really, within the second day of the Trump administration, both undid OFCCP at the Department of Labor, really makes the point about how much the administration does not believe in and does not like any kind of DEI. You know, it's termed illegal DEI in that initial executive order. At other times, there are references to immoral preferences, racial preferences, things like that. But clear direction to Acting Chair Lucas that this is what President Trump wants, and a clear direction that belief that DEI, however defined in whether corporate America, institutions of higher learning, nonprofits, foundations, over the past, say, 5 years in particular, swung too far. A clear belief that in many situations, companies may have been advocating for or actually had, in fact, preferences, set-asides based on race, based on gender, and particularly in light of the Supreme Court's decision 2 summers ago, in the Harvard UNC Students for Fair Admissions case, granted in the education context, not in the employment context, nevertheless, really undoing the notion of any kind of race-conscious admissions in higher ed. That, of course, has spilled over into the employment context. And there's been the cultural backlash against DEI. So the administration has been all about, we don't want to see this, particularly from federal contractors or, grant recipients, for example, in higher ed. So Acting Chair Lucas has acted on that, both in terms of the direction given by the President Trump's executive orders. But I have to say, on her own, even after the Harvard UNC case, she's been very outspoken about her own beliefs that the pendulum swung too far. I think probably her own experience. She was a corporate lawyer, big law firm in DC. I'm sure she's seen and advised on lots of DEI programs in her time practicing law, and a clear belief that too much attention on, and in fact, as I said, actual granting of preferences based on race, based on gender, and that violates the law. So she's done a couple things. One, she put out, and somewhat directed by the executive order, but a guidance document in conjunction with the Justice Department about helping employees understand what, and be able to identify what DEI discrimination, as she views it, might look like in the workplace, including suing over segregation. And I will say, Chair Lucas is a textualist, and she looks at the statute, and she has focused on, I think it's section 703 of the statute that says you cannot segregate employees. And she views many DEI programs, particularly those that have, for example, employee resource groups that may be confined to, certain races or genders or whatever the interest group, she views that as violating Title VII. And the other thing that she's done is and this was definitely an unprecedented move, and again, somewhat directed from President Trump's executive orders, but sent letters to 20 major law firms asking them to provide information about their DEI programs. Now, the authority of any sitting commissioner is that you can file, if you have reason to believe that there's some discrimination occurring in some workplace, you can sign a commissioner's charge. By the statute, those commissioner's charges are confidential. Acting Chair Lucas did not file commissioner's charges against any of these law firms, at least that we know about, we're aware of, because otherwise that would be confidential. Instead, she very publicly sent letters to them and issued a press release about the letters that she sent, asking for pretty extensive information from many of these law firms about their DEI programs. And did this based on just public information available, went on the websites of these law firms and said, for those who were touting their DEI programs or touting their mentorship programs, that maybe they were, or their internship programs, that maybe they had a racial component to them, just based on public information, sent letters saying, I, under my authority under Title VII, am asking you to send me this information. So certainly a big move and unprecedented move.
A lot of attention.
Definitely got a lot of attention. And as we have seen from President Trump's approach in the executive orders, where he's called out certain law firms, I think the response, to the best of our knowledge, back to Acting Chair Lucas, some have provided information. I know one law firm did. Goodwin Procter actually provided data to her. Some, I'm guessing, maybe took a different approach, but she also did, quote, settle, I'm putting settle in quotes, with some of the firms who agreed to make revisions to their DEI programs, change the language. I think that is what we are seeing by a lot of companies and organizations who, certainly if they haven't reviewed their DEI programs at this point, I don't know what they're waiting for.
Scrubbing them a little bit.
And I'm not saying, throw them out. I'm saying, what are you saying about your DEI?
Mm-hmm.
Some of this too, to be honest, I mean, I think all of us as lawyers would say that after George Floyd, a lot of people went a little too far. They a little carried away. And I think that with SFA coming out, conservatives have pushed back and said, Title VII says non-discrimination, period, end of story. And so that's part of the problem. And I think in addition to these 6 firms that were definitely targeted by the executive order against Perkins Coie, in which this is what Lucas went after them for based on her direction from the president. There were other firms that also settled. There's, as last check, nearly $1 billion in pro bono work from some of the best firms in the country. Interesting to see what they end up being asked to do by the president.
So a couple things, because we don't know whether this business addressing law firms is a one-off, whether it represents perhaps a new strategic approach in light of more limited resources the agency has to not necessarily invoke the formalities of a charge, but do this pre-charge with the public disclosure. That remains to be seen, whether this is a new chapter in the playbook or just, kind of a one-off addressed to this industry and these firms. Second, and Vicki, you touched on this about the confidentiality, but to the extent that anyone does face this in the future, this is a very different process that the law firms are in. It does not have any confidentiality. It's not even clear whether, if you supply information or documents, whether it's protected from FOIA, it can be shared within the executive branch. And indeed, under the work share agreements and the request by states attorneys general, the information often is shared, and that's where some of this information has actually been disclosed. It's been shared through standing work share agreements and or through the states independently piggybacking onto the claims and asking that information be provided to them. And then the states are responding to FOIA requests, typically from Bloomberg, and there the information shoots out in the public. So it's very challenging for employers and how to address this because there are procedural safeguards and benefits to all parties under the normal under the Title VII statutory prescribed process. There's confidential charge, confidential conciliation, and the government, unless there's a dispute over a subpoena, there's no public dissemination of it unless the charging party wants to, and rarely does one want to, until the government's really had a chance to make a decision on, is there in fact a bona fide basis? Does this charge have merit? This sort of presupposes and jumps that, and the dynamics are very different. The protection of parties' interests, documents, and information is extremely challenging. So,
well, and I will say to your point about, is this a one-off or is it going to be more law firms? I don't know. Certainly Chair Lucas knows the legal world well, yes, and knows big law. And that's where she comes from. So it's not surprising that she, in addition to direction from President Trump's executive orders, but it's not surprising this is a industry that she knows well and knows how it comes from that environment herself.
Well, and it's an industry, Anita, I'll jump right over to you a sec. It's an industry that Ed Bloom successfully highlighted in some of his 1981 claims, litigation claims, right, regarding summer programs and internship fellowships and so forth that were exclusionary, that were segregated, as Andrea would describe it. And all of those settled out. And one of those programs that changed actually was her former firm. So to your point, her prior experience, I think, helps influence a little bit where she comes from on this. Nita.
Two other things real quickly before we move on.
Yeah.
One is that, remember, on May 21st, the Attorney General was supposed to send to Stephen Miller a list of egregious DEI practitioners. So we can expect some of this same treatment to roll out. And we know that Lucas has sent a commissioner's charge to Harvard around their DE&I programs. We know that because it was published in the Free Beacon. Unclear exactly who published it, but I assume we'll see there's probably more of them out there that we don't know about.
Right. And the Harvard one to sort of multiple groups at Harvard, right? The university,
correct,
healthcare system.
But not the entire Harvard entity. They've selected
exactly.
different units.
Right.
And since we don't know who's on that May 21 list that was compiled per the steps each agency identified, these are not just contractors or grant recipients. It can be any company involved in egregious DEI, as the wording goes. We don't know if these other, I call it waiting for the shoe to drop. If these, I mean, there was in the last 24 to 48 hours a shoe drop on Columbia University. Is that a result of the May 21, or is that result of prior focus that had been given to Columbia? It's not clear. And so it's very hard to navigate some of this because we don't know.
And all we know from President Trump's executive order was that May 21st was the deadline by which a report was supposed to go to Stephen Miller.
And we certainly have information.
We don't know any more about that.
We don't know the content, but we have information that in fact it did go from, it was prepared comprehensively and did go from the Justice Department to the White House as scheduled. So what happens next?
So let's talk about, before we can talk about DE&I till the cows come home, but let's talk about some of our other ones. Going to the next slide. I think not a big surprise from Trump 1.0, religious freedom continues to be a hot topic. Anti-Semitism, like DE&I, is another hot button issue for this administration. And she's already issued press releases and has gone after a number of universities for alleged anti-Semitism in not protecting their Jewish professors and employees during the protests against the war in Gaza. She's also, on the flip side, she's also participating in the task force to eradicate anti-Christian bias in the federal government. I think many people saw the Secretary of State, Rubio, is investigating anti-Christian bias within the State Department, for example. And the last thing I wanted to point out, which I'm not sure, I certainly didn't realize this, during the pandemic, there were lots and lots of charges filed. Over 10,000 charges were filed alleging religious discrimination against those people who did not want to take the vaccine, and their companies had a mandate. EEOC, according to Lucas, has recovered over $54 million for those individuals who were not adequately provided with an accommodation, which I don't know about you guys, I found that very surprising.
Yeah, a little bit. We had some clients that actually had some of those charges pending that we did try to hustle towards the end of the Biden administration to get resolved, because we were a little concerned that a different focus on different highlighting emphasis on religious protection might result in this. I just also want to call out this task force to eradicate anti-Christian bias. I think we're going to hear much more about that downstream. Most of the oxygen in this space is being consumed with anti-Semitism at this point, but there's a clear marker down on this anti-Christian bias, significant government-wide multi-agency marker, and the EEOC will be part of that. And I think that we will see significant developments in that as we move forward.
And that is something that Chair Lucas cares about a great deal. It's not just, hey, you're got assigned to this task force within the government. That's been something that she has said from the time she got to the commission.
From the
It's a
get-go.
priority of hers.
I agree with that. I agree.
So David, I think the next one is one that we all think is a little bit surprising.
Yeah, well, yeah, yes and no. I mean, the prioritization against anti-American bias. And so this is one where, of course, we know national origin is a protected basis under Title VII. And so we think about national origin, and that typically refers to where one is born. That is part of your heritage component. Whereas citizenship is something that you can change. I mean, you literally can give up your citizenship. Not many people do that, but sometimes you can acquire citizenships. Got members of my family that have acquired. They're both American and have citizenship in other countries. That can occur and does occur. And so when we talk about Americans losing job opportunities because of this anti-American bias, I mean, the only tool that you have available under Title VII, you have to shoehorn that into national origin. There is a protection against discrimination based on citizenship. That, of course, is in the immigration statutes, IRCA and other statutes that the Justice Department has. EEOC has no role, or traditionally, and to my knowledge, still doesn't have any role in enforcing that. So this reference about we're protecting American jobs against others that come in, it is possible to frame up national origin claims. This one, we've got the brief settlement here about a Japanese-run lodging facility that was in the
Guam, I believe.
Guam. Yeah, I was going to say one of the American territories, Guam. Yeah, and where they were discriminating against non-Japanese. Okay, that's okay. And sometimes you see this. I've seen it in construction claims. Is sometimes where you do see national origin claims. But the broader. My only point is there is some looseness, I think, about when they talk about, quote, Americans. American could be a nationality, but more often they're really loosely talking about citizenship. But we'll see. I want to see how this plays out. National origin's a legitimate thing. It's a protected basis under Title VII. So, and it could be deployed in proper circumstances in that manner.
Well, and I will say, in my time at the commission, there were a number of cases that we had that were, the hiring charge to the hiring manager was, we only want, immigrant workers, Hispanic workers for these jobs, right? So there was sort of the foreign preference. And like you said, that sort of most naturally comes under national origin, but it's not a new thing. Certainly, as Chair Lucas has framed it about, I want to protect American workers. It's part of President Trump's immigration agenda. There's no question about that. But it's not a new thing to the EEOC. And it has been developing over the last 15 years.
It's really whether she can take these broader, what are social media points, the way the administration describes these issues, and then get them grounded into the Title VII national origin framework. Right. That's more how I see this issue. All right.
I think the next issue, Vicki, is one that really is near and dear to Lucas's heart.
Well, right. So again, right out of the blocks, right on the first day that Chair Lucas was named as the acting chair under President Trump, and she made it very clear among her priorities that, and I'm quoting here, defending the biological and binary reality of sex and related rights, including women's rights to single-sex spaces at work. So she's been, again, very clear from the beginning, even, again, back to her time just as commissioner before she was named acting chair. And again, following President Trump's executive order about very specifically about gender ideology and only recognizing binary male, female, and that would be the official policy of the federal government in all aspects. So again, it both coincides with her own priorities and the direction from the White House, but she took some very specific actions right away, including directing just for employees at the EEOC that they they had to remove from their signature line on any internal emails any sort of preference in terms of gender, pronoun. Right, preferred pronouns. Thank you. And then withdrew from the EEOC, of course, had brought a number of cases. They were actually in litigation lawsuits on behalf of transgender workers. She had the EEOC withdraw from those lawsuits. I know in at least one case, the judge waited and would not allow the dismissal from the EEOC until was assured that the individual had representation, legal representation. And also has cut funding to the state FEPAs, the Fair Employment Practices Agencies among the states, for it's essentially how they are reimbursed for any cases that they might be handling, investigations, charges related to trans workers. So some very specific.
Excuse me on that last point, because that's kind of a little inside baseball. So if a state agency would opt to investigate a transgender claim under a FEPA arrangement, it could not seek reimbursement from the EEOC at this juncture.
They won't get paid.
They won't get paid for it, at least by the Fed.
They can
draw it out of their state treasury.
Yes.
Yeah, the state and local governments obviously also have their own state and local rules around this, and they would, they might not be getting money from the federal government, but if you're in a state that recognizes this, you could still file a charge, obviously. One last item. I'm sorry.
On this, I just want to say that, again, very, very specific actions by Chair Lucas. I do think this, and by the president's executive orders, but I do think this puts the agency in tension with the Supreme Court's decision in the Bostock case, which clearly said that the because of sex language covers sexual orientation and transgender individuals. The chair has the governance model at the EEOC. It is a strong chair. The chair makes all of the administrative operation decisions. You put your resources where you want them to go. But this is clearly not a priority for Chair Lucas. But I do think as a legal matter, it puts the agency in tension with the.
Can we just linger on the legal point for a sec on that? Because we have Bostock and we have Justice Gorsuch's decision, which, and some of the attention has been spent on bathrooms, and Justice Gorsuch, his opinion, if you go back and read it, which I've done several times since this whole issue has come up, he said, well, we're deciding on these terms and conditions. We're not addressing other issues like bathrooms. So he, in the opinion in that case, carved it out. Then we have the Muldrow next layer as we look at the Grand Canyon of precedents, right? And Muldrow basically says very broadly terms and conditions, which of course I think does include a washroom at work. But the court itself hasn't put that back together. And it seems to me that what Acting Chair Lucas is relying on is, look, I'm looking literally at the Bostock case as it's written. That's what it says. I don't have to extend it any further than that. I certainly don't have to go to bathrooms, which they said was out of bounds. But that's, I think, the underlying legal argument back and forth.
Yes.
And I say that only because I've heard somebody say, well, the EEOC is now completely unprincipled what they're doing. I don't find that. I mean, I find that they've taken a different tack, certainly.
Yes.
But not that it's legally ungrounded or untethered.
Well, as you point out, there is language
Right.
to rely on in the
right.
Bostock case. Yeah, I'm just saying it as a general matter, right? There was a lot of
That's quite different than it
Yes.
was in December.
Yes.
Yes.
Very different, including the one of the things Chair Lucas has said is under the Biden administration, Chair Burrows, the commission had finally finalized guidance related to harassment in the workplace, and that included, and that was something that we had worked on when I was there. Bostock had not been decided at that point by the Supreme Court, so once that was decided, the commission then issued guidance under the Democratic majority that included issues like pronoun preference and harassment issues related to that, which, again, to her credit, Chair Lucas, as a commissioner at that time, put out a statement saying, I disagree with this.
She actually filed written objections, written statement that be like filing a dissenting opinion in a court, appellate court proceeding. Yeah.
We'll talk about the status of that harassment guidance in just a minute. As we move on, guys, we're going to run out of time as we always do because there's so much to talk about. I just want to, lastly, in this 120-day letter that Lucas sent out, she pointed out they're fighting for veterans with disability, which we all thought was a little bit interesting. And then the budget comes out and says OFCCP is being annihilated. It will go away after the new Congress, the new budget goes in, and 503, which also covers disabled veterans, would move to EEOC. So it made more sense when she said that. VEVRA, though, it looks like it's going to stay with vets, which Department of Labor, rather than moving over to EEOC.
And that 503 transition, that would require a congressional
Correct.
Amendment to the statute, whereas VEVRA, I believe, can just be reassigned because Congress assigned that to the secretary, right? I mean, Vicky used to run VEVRA and 503.
The secretary could issue an order right now. It
Yeah.
doesn't even have to. Now, she wouldn't be able to transfer employees because that would take a reprogramming from Congress, but the secretary can issue an order right now and say the authority for this is now with the vet's office at DOL. One thing I will say on the disability issue in the 503, and I was asked this by a reporter the other day, I think that, first of all, I don't think you can match the EEOC's expertise in disability law. So to me, it makes a lot of sense that obviously they're, being handed this, but it's not a new issue for them. It's not a new area of the law. They are the experts on disability law. So this is just another aspect of it. I think that the question is under how 503 was administered by OFCCP, there were actually affirmative action plans. So query whether, assuming Congress goes along with this and does this transfer, which would happen in the budget document, when and if it goes to the EEOC, what happens to those regulations? I do not see in any way the current 503 regs under the auspices of the now outgoing OFCCP.
Picked up and moved over.
I do not. No, I do not see that happening. And how regs in any way and the enforcement of 503 by the EEOC is reimagined per the statute, what Congress wanted in the statute, I think that remains to be seen. But it's not going to be, oh, we're going to do those
Well,
AAPs just like we've been doing them
Yeah.
under OFCC.
well, my recollection, 503, although it authorizes affirmative action, I'm not sure it mandates that
Correct.
a plan, that a document, that
Correct.
annualized document. I mean, that's the Labor Department mindset, and of course, it grafted onto the other programs that they then were administering. But
Right.
so it's conceivable that 503 could really morph and become very ADA-ish in large part, and I
Right.
think that's where it's going.
Right.
Yeah.
Which, you know,
It's
I
a
mean, in terms
histo-
of consistency in the law, that may not necessarily be
I was
such
gonna
a
say
bad
it's
thing.
somewhat of a historical acronym,
Yes,
anomaly
the
at this
ADA
point
is.
that we have these two programs. ADA, even though it's the younger of the two, has effectively superseded
Yes.
the field.
Yes.
Sure. Yeah, I think that's right. Well,
So I think we need to talk about disparate impact before we
yeah,
get.
I was gonna say one of the other very significant things, and this certainly does, pardon the pun, impact EEOC. But we do have President Trump issuing the order 14281 that is quite significant. I mean, when you sort of think about kind of the landscape, whereas disparate impact has been for decades part of the Title VII framework. It in fact is codified now in the statute. It wasn't originally. It was first recognized by the Supreme Court in the Griggs case, was codified in the 1991 Civil Rights Act. So we're talking 33, 34 years of it being a statutory term. Yet when you read the president's executive order, it's like, oh my God, this is terrible. It's resulting in all these horrible, unlawful problems and resulting in unlawful discrimination. It's actually causing unlawful discrimination. Well, respectfully, that isn't true. I mean, that's just flat out, that is not true. That's not accurate. What I think the primary objection that many had that supported this executive order was the remedy that could be imposed, that there wasn't ever, you didn't have to have an indication. There was no intentional discrimination. If you simply had a program, then you would design a remedy that would specifically benefit certain protected groups and by definition disadvantage other protected groups as part of a remedial remedy. And that, in the absence of any intentional discrimination, I think became sort of the lightning rod that drew a lot of criticism, starting actually with Justice Scalia, who sort of launched this, even though he himself, Justice Scalia, recognized that there was a legitimate reason for agencies to collect data, to look to see whether there were statistical disparities, as, if you will, a jumping off point. The justice put it much more eloquently, but effectively a jumping off point, and then to determine whether there had been unlawful discrimination. But whether statistics alone, that was kind of the bugaboo for many, and that certainly is, if you will, the bugaboo for President Trump. And he has said, look, the statute is what the statute is, but as a matter of prioritizing how we spend federal resources on my watch, we are not going to enforce that provision of the statute. Of course, it does leave, there are private causes of action available. And of course, many states do have this codified as part of their statutory scheme. So attention employers, this is not a get out of disparate impact jail free card. It still exists, but it has deep kind of powered down. This was used particularly in the public sector by the U.S. Department of Justice Civil Rights Division for police, fire, and if you think about promotion tests, physical ability tests, et cetera, whereas routinely impact cases were asserted, more often than not settled with a consent decree typically, and then there was a monitoring for a period of time, often many, many years worth of monitoring. And this, I think, became another rallying point for the critics, which is these things never end, and we need to have an end point. You don't get found to have violated, do curative steps, but still have to keep monitoring. So
well, and you've seen that withdrawal by the Trump administration across agencies,
Right.
not just the EEOC. I mean, disparate impact is used by many agencies, but withdrawing from, and particularly like you're saying, Justice Department enforced prior consent decrees that date back decades
decades.
that they have now
decades.
withdrawn from.
And really in the last, 2 weeks or so, since, I mean, with kind of an amazingly rapid fire, where the Justice Department affirmatively goes into the court and says, we no longer believe that these requirements are necessary. We want the decree dissolved. And typically, of course, the municipality goes, great, thank you. One, we don't have to keep reporting and checking in.
But one important point related to what you said. So I think for EEOC purposes, even though, yes, the EEOC has had this authority in the statute and has used it, the real force that the EEOC has is pattern or practice authority.
Pattern of practice, disparate treatment.
Yes,
Right.
which are also statistical models. You use statistics. Chair Lucas has said, and she knows how to use that data collection and that information in terms of statistics and what it can show for pattern or practice purposes. So if I were, for employers, I wouldn't get so excited about, and also because, as pointed out here, private litigation, the plaintiff's bar can still use Title VII. So they're not going away.
This does not, let's clarify, to make and confirm, so because there's a lot of misunderstanding. This does not mean that statistical claims will not be asserted by EEOC.
Correct.
We're involved in some matters right now where the agency is vigorously arguing that based on statistical results and other evidence, that there's a pattern in practice. Additionally, our experience with the EEOC has been that they view the president's order as addressing Title VII. It does not, in their view, extend or expand to ADA and other statutes
Correct.
that they
Yes.
protect. So I don't want anyone to overread. This is a significant executive order. Again, I think there was a lot of sound and fury, but if you sort of bring it down to what it is, it's a material change. But frankly, if you look at the number of cases that the EEOC brings,
Correct.
a couple dozen a year-ish, give take, are larger systemic cases. Of those, you can typically in a typical year count on one hand.
Yeah.
Those that were disparate impact. So
Yeah.
we're not talking
Right.
knocking out a whole
Right.
huge segment of claims that the EEOC had previously been
The
pursuing.
pattern or practice authority.
It's the pattern, that's the bread and butter. Nita.
Okay, so we have 8 minutes
Oh,
before we
boo.
are going to end this. Okay,
Just
so
getting
let's
going.
go
Just
to the
warmed
next
up.
one. I know, we can do this for hours. So Vicky, what happened with the harassment guidance? Give us a very high level.
Right. So the harassment guidance that the EEOC put out under the Biden administration, Chair Burrows, again, when I was there, we were trying to get this guidance out. And, an update to look, a lot changed in the harassment world, beginning with, the Me Too movement in 2017 and on, and the task force by the EEOC. And then, of course, the Bostock decision. So include, coverage for sexual orientation and transgender rights. So again, an extensive guidance document, but an enforcement guidance document, not a regulation. So a sub-regulatory document that was then challenged in federal district court in Texas, and the portions that talk about LGBTQ status and how people can be harassed based on that, the pronoun usage, the locker rooms, bathrooms, all of that vacated by the federal district court. And saying, as we say here, that the commission took this overly expansive view of Bostock. So to what David was saying earlier, and who knows when, if the Supreme Court will ever will revisit terms and conditions per the Muldrow case, and the locker rooms, bathrooms issue per the Bostock case, and try to square that circle at some point. Who knows? But so the status, though, Chair Lucas had said she had also issued a statement saying why she was voting against that guidance document. I would guess that it's a very extensive document, that there's a lot that she certainly agrees with. It's pretty standard harassment law. particularly post Me Too.
Right.
But I think once she has a quorum at the EEOC, once there's a Trump administration quorum, clearly that will be revisited. I am just really curious about the federal district court reaching down into a sub-regulatory document and I think blue penciling as your or redlining,
Yeah,
right?
blue pencil. I mean, talk about
when-
micromanaging an agency. Whoa.
Yes, yeah,
I mean, this is an example, I think, of an
Apparently,
activist court,
this-
even though.
right.
Yeah, he is. He ran the immigration during the Biden administration. All right, guys, we're going to run out of time.
That's
Mr.
right.
Courtney, how about
I'll quickly
abortion?
touch on PWFA, Pregnancy Worker Fairness Act, where again, we had a district judge this time in Louisiana that did address the purely elective abortion issue and struck that from the PWFA regulations. The PWFA regulations, again, the Pregnancy Worker Fairness Act actually authorized the EEOC to issue regulations. Most of the statutes it enforces, it's not authorized to issue regs, which is why you have all these guidances and all these other sub-regulatory things floating around. Number one. Number two, one of the consistent threads we've seen throughout in real time when this was issued, this regulation was issued very broadly to include elective abortion. Now Acting Chair Lucas dissented and filed a pretty detailed written dissent. I found interesting that not that this particular judge would strike that provision or find it unauthorized, but that he allowed the rest of the regulation, which, by the way, is broadly supported by almost all interest groups. It's the abortion issue alone, but he sort of allowed that to be carved out and allowed the rest of the regulation to go forward. Typically, when a regulatory provision is stricken, the regulation itself, it all falls down because of the interplay between with other provisions. But in the event,
I think the EEOC put a severability clause
They
into
did
the
put-
regs.
They
so
did.
well,
it's
yeah.
actually,
clear-
the Biden administration began to do that in
Uh-huh.
all their regs, the Labor Department, EEOC, kind of anticipating, but it's the first time I've actually seen it being effected. So anyhow, for what it's worth, there
So
it is.
guys, yeah, EEO1, just portal opened. It's only open for about a month. They eliminated the non-binary reporting, obviously, in reaction to the executive order. There was a very interesting, if you haven't already seen it, Lucas sent out a notice with it, basically saying, don't, you've got Title VII, don't make decisions based on race and gender, which, hello, we already knew that. But she
It's
also,
a little defensive, but okay.
yeah, she went ahead and said there's no diversity exception to titles. Okay, fine. I think let's go to the very end here, David. What's going to happen next? Let's just go to that. What's going to happen next, Vicky and David?
All right, Vicki, why don't you jump off?
So I think it is very important that employers not have an assumption that just because this is a Trump administration directed EEOC, that there's any taking your foot off the gas of enforcement. Chair Lucas made her credit, made her priorities clear, consistent with what she was saying as a commissioner. There are certain cases and certain issues that she thinks need to be addressed by the commission. But your run-of-the-mill discrimination, and I don't like to call any discrimination run-of-the-mill, but there is plenty of good old-fashioned discrimination to go around. I used to say this all the time, on every statutory basis. And I think she has been very clear that she expects the commission and wants the commission to have vigorous enforcement, and employers should not take their eye off the ball of what your standard preventative anti-discrimination practices are, trainings, all of that in your workplace.
Of course, once there's the quorum in place, we've talked about the regulations, the guidance will be changed. I just think that what's happened is that the focus on DEI and the disparate impact executive order has preoccupied. That's become sort of the shiny object, and many employers, I think, have sort of lost situational awareness. So I think that point is so important. Well, let's look at, Nita, what's still to be determined.
Well, I think there's a whole bunch of stuff to be determined. I know we're about to run out of time, but are they going to eliminate these our EEO1 report? I think that's possibly likely once they get the quorum. And Vicky, I know we worry about things like UGS and AI and background checks. Aren't those all just some regulatory guidance that can be changed? Some of it they've already dropped. I think the AI guidance has vanished.
AI guidance that the prior EEOC had put out has been taken down. That was not a document, two documents were never voted on by the commission. So it could be the case that, the thought is we'll develop something else. But who knows? I mean, the administration has a very pro-innovation approach in terms of AI. UGESP are only guidelines of the EEOC, even though they are in the regulations, Code of Federal Regulations. They're not official regulations. Criminal background checks, that is a enforcement guidance sub-regulatory document. It was controversial when we put it out when I was there. So has a big component of it that is disparate impact oriented. There is disparate treatment as well. So query whether that might be revised somehow. Yeah. So, and then also the last point that the proposed budget for the commission is a $20 million reduction. And, $20 million when most of your agency is all about staff has an impact.
Close a few offices, then you can save on overhead for buildings too. Well, we'll see how that works out, but I agree.
Well, the last thing I think, David, we want to point out is as we're going to close here, we have our resource page for everybody. And you guys want to, since we got just 1 minute, anything else we need to provide to them before I do the closing?
I don't think so. I think so. I mean, I just think, Vicki, I want to thank you and so much really detailed information. And I think that the clear takeaway is EEOC is very much open for business, notwithstanding not having a quorum. And every best practice training, harassment training, monitoring your workplace, collecting data, making sure you don't have practices that are subject to a pattern and practice claim, et cetera. That is 100% still on the table and should be part of your playbook.
Absolutely.
So,
yes. Thank you for inviting me.
Yes, we're glad to have you.
Well, we'd like to thank everyone for joining us. If you have further questions, please email us at information@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar, and thank you all for coming.
Thanks, everyone.
Thank you.
Bye now.